Have you ever wondered what it's like to take on a giant in court? When you're fighting for your rights in a personal injury lawsuit, you're up against not just the defendant, but also their insurance company and their legal team. It can feel like you're David facing Goliath, but you don't have to give up hope just yet. We fight Goliaths in court every day, and in this video we're going to walk you through each stage of a personal injury lawsuit and guide you through the twists and turns so that you have the knowledge and confidence to take on huge opponents in court. So buckle up and let's dive in. The first stage of a personal injury lawsuit is the pleading stage. Think of the pleading stage as the opening salvo in the legal battle. This is when you file a document in court called a complaint or a petition that's going to identify the defendants you are suing, describe what they did wrong, and inform the court about the types of damages that you're seeking. Now, once you fire your opening salvo with your complaint, each defendant in the case gets to return fire. Most times they do this by filing what's called an answer to the complaint, either admitting or denying the allegations. The answer might also allege legal defenses that the defendant will try to prove to defeat your claim. For example, if you broke your ankle when you stepped into a pothole in a Walmart parking lot, you might file a complaint alleging that Walmart failed to maintain the parking lot in a reasonably safe condition. Then Walmart might come back and say that you were comparatively negligent because you should have seen the pothole and avoided it. It's kind of like a game of chess. You make a move, then they make a counter move. Once both sides have made their opening moves, it's time to gather intel in the discovery stage of the case. This is where both parties use every legal tool at their disposal to gather evidence to support their case. It's basically a battle of wits to see who can uncover the most convincing evidence. Some of the tools we use to uncover evidence to support your case are interrogatories, requests for production, depositions, and subpoenas. Interrogatories are just written questions that we can send to the other side, which the other side has to answer under oath. We send a request for production to get documents and evidence the other side might have, and if there are others who have documents or information that might be relevant to your case, we use subpoenas to get that information from those non-parties. Depositions are simply a Q&A session where a witness is asked questions by an attorney under oath. There will be a court reporter there taking down what everyone says and locking them into their story. We use depositions to find out what the other side or what third-party witnesses might say at trial if the case goes that far. If you are a party to a personal injury lawsuit, you will probably have to participate in a deposition and answer questions from the other side's lawyer. And it's important to take this part of the case seriously because what you say in your deposition can be used against you when you testify at trial. So you'll want to spend plenty of time preparing with your attorney for your deposition. And if you're one of our clients, we will walk you through our deposition preparation process and make sure you are able to testify confidently when the time comes. Okay, so discovery is completed and you're feeling good about the evidence that you uncovered. Just when you think you have the upper hand, a plot twist comes when you get to the dispositive motion stage of the lawsuit. This is when the other side tries to dispose of the case by filing what's called a motion for summary judgment. A summary judgment is exactly what it sounds like, a judgment by the court in summary fashion without having a jury trial. And what the defendant will try to do is ask the judge to enter a summary judgment and dismiss your case based on the evidence that's been uncovered during the discovery stage. The defendant is basically saying to the judge that the evidence is so lopsided against you that no reasonable jury could ever find in your favor, so there's no point in having a jury trial. And if the judge agrees, your case would get dismissed. So there's a lot on the line when a defendant files a motion for summary judgment. When we respond to these motions, we file a comprehensive opposition brief that lays out all the evidence in your favor: deposition testimony, witness statements, interrogatory answers, documents, reports, you name it. And we'll explain in our opposition brief all the reasons your evidence is sufficient to win under the law. We really want to pour it on the judge so the judge not only denies their motion, but sees that you have a very good case, and the defendant's lawyers like to waste time with stupid motions. And that kind of thing makes judges angry, and having a judge angry at the other side never hurts. So when the defendant tries to throw a plot twist into your lawsuit story, sometimes you can turn it into a winning advantage. If the case makes it past the dispositive motion stage, it's time for the main event, the trial. This is where both parties will present their evidence and arguments to a jury. It's like a courtroom showdown where both sides are fighting for their version of the truth. It's the ultimate legal drama with the fate of your case in the hands of a judge or a jury. The trial can last anywhere from a couple of days to several weeks, depending on how complex the case is. The trial will start off with jury selection, where each side will try to remove jurors that we think will be biased towards one side or the other. Once we have a jury selected, both sides will present opening statements to the jury where we will explain our case and outline the evidence that we're going to present. Then the parties will call their witnesses and present their evidence to support their claims and defenses. As the plaintiff, our side gets to go first. So we will call our witnesses and present our evidence, then the defendants will get to present theirs. Every time a witness is called by one of the parties, the other party's attorney will get a chance to cross-examine the witness to poke holes in the witness's testimony. Once both sides have presented their case, the attorneys will make closing arguments to the jury where we will summarize the evidence and explain why the jury should rule in our favor. The judge will then give the jury some instructions on how to apply the law to the facts established by the evidence. Then the jury will go into a private room to deliberate. If the jury finds in favor of the plaintiff, they will award damages. The amount will depend on what they believe is fair compensation for the harms and losses you suffered due to your injuries. And if the jury finds in favor of the defendant, then they won't award any damages at all. Once the jury returns its verdict, the judge will then enter a judgment declaring who won, and then that's the end of your trial. But if either side isn't happy with the outcome of the trial, they can appeal the case to a higher level court. Think of an appeal as a sequel to the main event, where both sides will present arguments to a panel of judges who will then make a decision on the case. It's a chance for one side to get a second shot at justice or for the other side to defend their victory. If the Court of Appeals believes an error occurred during the trial, the appeals court will reverse the trial court's judgment and send the case back down for a rematch, and the parties would have another trial. If the Court of Appeals doesn't believe there were any errors, then the judgment will be affirmed, and then that's the end of the story. Now, you're probably wondering how long all this takes. Well, based on what I'm seeing right now in the courts where I practice, cases are being set for trial about 18 months after the filing of a lawsuit. It could take longer if your case gets continued or you need more time to complete discovery because you have a complex case. And if the case goes up on appeal, that can add another 18 months or so to the process. So that's about 3 years. But don't freak out. Very few cases go on that long. Very few even make it to trial. And that's because the parties always have the option to opt out of the lawsuit process by agreeing to a settlement. Over 90% of lawsuits end up settling, especially if your lawyer is turning up the heat on the other side during the lawsuit. And if you want to learn more about how lawyers like me value injury cases for settlement, watch this video here. And if you'd like to talk to me about an injury case, use the link below to send me some information about your case, and we'll reach out to you to set up a time to talk. Thanks for watching. We'll see you in the next video.